Nobody talks about this. 29 federal judges just united against Trump in a move that's sending shockwaves through Washington. A full bench of 29 appellate judges just voted to vacate a ruling that favored Trump, every single one of them. This isn't isolated anymore. It's a coordinated judicial rebellion. From immigration showdowns to funding battles, courts are hitting back hard. Even Chief Justice Roberts issued a rare rebuke. The message? No one is above the law, not even a president. The judiciary is drawing a line in the sand. Will it hold? Drop A if you're watching this unfold.
To get to business. I love that song, but I want to thank you all. You're special, special people, and I want to just say that, I announced I was coming over here, and I said, you got to win the midterms, because if we don't win the midterms, it's just going to be, they'll find a reason to impeach me. I'll get impeached. We don't impeach them. You know why? Because they're meaner than we are. We should have impeached Joe Biden for 100 different things. They are mean and smart. But fortunately for you, they have...
The relationship between the executive branch and the federal judiciary has reached a critical inflection point in modern American governance. What began as isolated friction has evolved into a systemic confrontation that legal scholars are calling one of the most significant constitutional stress tests in generations. At the center of this storm stands an administration that has fundamentally challenged the traditional boundaries of executive power and a judiciary that has responded with unprecedented unity and force. The pattern of engagement between President Trump and the federal courts reveals a dramatic departure from historical norms. Unlike previous administrations that typically accepted judicial oversight as a constitutional constraint, this presidency has adopted a confrontational posture that treats adverse rulings as political attacks rather than legal determinations. The implications of this shift extend far beyond any single policy dispute. They strike at the heart of the separation of powers that has defined American democracy for over 2 centuries. Federal judges, appointed for life precisely to insulate them from political pressure, have found themselves the targets of sustained public campaigns. These are not abstract criticisms of judicial philosophy or disagreements over statutory interpretation. Rather, they represent direct personal attacks on individual jurists who have issued rulings against administration priorities. The consequences have been immediate and severe. Increased security details at federal courthouses, threats against judges and their families, and an atmosphere of intimidation that the judiciary has never before faced at this scale. The administration's rhetoric has been remarkably consistent in its disregard for judicial independence. When courts have blocked executive orders on immigration, environmental policy, or executive privilege claims, the response has not been legal argumentation or appeals through proper channels. Instead, the administration has deployed a vocabulary of delegitimization, labeling judges as corrupt, their decisions as politically motivated, and their authority as questionable. This represents a fundamental challenge to the constitutional order, suggesting that executive power need not yield to judicial interpretation of the law. What makes this moment historically significant is not merely the volume of these attacks, but their specificity and their consequences.
I want to be very clear. You have misused resources appropriated by Congress. You've engaged in unethical behavior. You have repeatedly made false and misleading statements to Congress and to the press, and you've undermined the separation of powers and disregarded the role of Congress and the courts. Bottom line, you lie with impunity, you reject checks and balances, and you ignore Congress and the courts. Your options are limited. Either you're going to resign, Trump's going to fire you, or you will be impeached. I've already called for your resignation. You may remember I hand-delivered my request to you back in May, and I urge you to reconsider resignation because I've taken the first step towards your impeachment, and I've called on the Judiciary Committee to open an investigation.
Previous presidents have certainly expressed frustration with judicial decisions. Franklin Roosevelt famously attempted to expand the Supreme Court after setbacks to his New Deal legislation. Richard Nixon railed against activist judges during the Watergate era. But neither systematically targeted individual trial judges by name, nor did their supporters subject those judges to sustained harassment campaigns. The current situation presents a different character entirely. Federal judges presiding over cases involving administration policies have faced doxing, death threats, and coordinated intimidation campaigns organized through social media platforms. This has necessitated unprecedented security measures, with some judges requiring around-the-clock protection. The Administrative Office of the United States Courts has documented a surge in threats against the judicial branch that correlates directly with the administration's public statements targeting specific jurists. The judiciary's response to this pressure has been measured but unmistakable. Rather than retreating into institutional silence, federal judges have increasingly chosen to document their concerns within the official record of their opinions. This is a significant development in itself. Federal judges typically avoid political commentary, recognizing that their legitimacy depends on public perception of their neutrality. When they choose to speak, particularly in written opinions that become part of the permanent legal record, their words carry extraordinary weight. The language emerging from federal courts across the country has grown increasingly urgent. Terms that rarely appear in judicial writing, contempt for the courts, unprecedented disregard for constitutional limits, threats to the fundamental principles of law, have become recurring features of opinions addressing administration conduct. These are not casual observations. Federal judges select their words with extreme care, knowing that their opinions establish precedent and shape the development of American law. The consistency of this language across multiple jurisdictions and judicial philosophies suggests something beyond individual frustration. Conservative and liberal appointees alike have employed strikingly similar characterizations of administration conduct. This convergence indicates that the judiciary, as an institution, perceives a genuine threat to its constitutional role that transcends ordinary political disagreement. Chief Justice John Roberts, who has presided over the Supreme Court with a commitment to institutional restraint, found it necessary to issue a rare public statement directly addressing the administration's conduct. When the Chief Justice of the United States intervenes in political discourse, it signals that the stakes have reached a level that threatens the judiciary's fundamental functioning. His statement, emphasizing that impeachment is not an appropriate response to judicial decisions with which the executive disagrees, represented an extraordinary break with tradition. This intervention was not merely theoretical. It came in direct response to the administration's calls for impeaching federal judges who had issued rulings blocking executive policies. The Chief Justice's message was unmistakable. The judiciary would not accept intimidation as a substitute for legal argument, and the constitutional structure would be defended even against executive pressure. The significance of this moment cannot be overstated. The Chief Justice occupies a unique position in American government, nominally co-equal with the president, but possessing neither electoral mandate nor enforcement power. The judiciary's authority rests entirely on public acceptance of its legitimacy. When that legitimacy is systematically undermined, the entire constitutional structure faces a crisis that cannot be resolved through ordinary political mechanisms. What has emerged is a confrontation that tests the resilience of institutional checks and balances in ways that American democracy has rarely experienced. The administration's strategy appears designed to erode public confidence in judicial independence, creating space for executive action unconstrained by legal oversight. The judiciary's response has been to assert its authority through the only means available, legal process, documented in opinions that create an official record of constitutional resistance. This dynamic has created a situation without clear precedent in modern American history. The courts possess the power to interpret the law and issue binding orders, but they rely on executive compliance for enforcement. When the executive branch signals its willingness to disregard or defy judicial authority, the constitutional system enters uncharted territory. The question becomes not merely who will prevail in specific disputes, but whether the fundamental structure of separated powers can survive sustained executive challenge. The stakes extend beyond immediate policy outcomes. The immigration cases, the environmental regulations, the claims of executive privilege, these are important disputes with real consequences for millions of Americans. But they are also vehicles for a larger constitutional confrontation. Each ruling against administration policy that is met with defiance or delegitimization represents another step toward a genuine constitutional crisis. Legal scholars across the political spectrum have recognized the gravity of this moment. Conservative jurists who have spent careers advocating for judicial restraint have found themselves aligned with progressive colleagues in defense of institutional independence. The American Bar Association federal judges associations and law school faculties have issued statements emphasizing the importance of judicial independence to constitutional order. This unusual consensus suggests that the threat perceived by the judiciary is not merely partisan disagreement, but a fundamental challenge to the rule of law itself. The historical parallel most frequently invoked is the Nixon administration's confrontation with the courts during Watergate. But even that comparison understates the current situation's uniqueness. Nixon ultimately complied with Supreme Court orders, however, reluctantly. The current administration has signaled no such acceptance of judicial supremacy in constitutional interpretation. Instead, it has treated adverse rulings as temporary obstacles to be circumvented through executive action or political pressure. What emerges from this analysis is a picture of American constitutional democracy under sustained stress. The judiciary, designed to be the most insulated branch, has become the primary battleground for competing visions of executive power. The outcome of this confrontation will shape not merely the Trump presidency, but the fundamental character of American government for generations to come. The federal judiciary has begun deploying its most powerful institutional weapons in response to sustained executive pressure, marking a decisive shift from rhetorical resistance to active enforcement of constitutional boundaries. This evolution represents more than tactical adjustment. It signals a fundamental recognition within the judicial branch that traditional constraints on executive overreach require active defense through the court's inherent powers. Contempt proceedings have emerged as the primary mechanism through which federal judges are asserting institutional authority against executive defiance. These are not routine procedural matters. Contempt of court represents the judiciary's ultimate enforcement tool, carrying potential penalties that include substantial fines and imprisonment for officials who willfully disregard judicial orders. The deployment of this mechanism against a sitting presidential administration is extraordinarily rare in American history, occurring only in moments of genuine constitutional crisis. The significance of contempt findings extends far beyond their immediate legal consequences. When a federal judge holds executive officials in contempt, they are formally declaring that the administration's conduct has crossed a line that threatens the judiciary's fundamental functioning. This is not merely disagreement over policy or interpretation. It is a determination that executive conduct has become lawless in the technical legal sense, violating obligations that bind all citizens and institutions within the constitutional system. Several federal courts have initiated contempt proceedings against administration officials in immigration and deportation cases where executive agencies have disregarded explicit court orders. These actions demonstrate a judiciary unwilling to accept procedural compliance as a substitute for substantive adherence to legal authority. The message is unmistakable. Judicial orders are not suggestions to be followed when convenient, but binding legal obligations that the executive branch is constitutionally required to obey. The pattern of these proceedings reveals a coordinated institutional response rather than isolated judicial frustration. Multiple courts across different circuits have employed similar reasoning and similar remedies, suggesting consultation and coordination among jurists who recognize that individual resistance may be insufficient against organized executive pressure. This coordination itself represents a significant development. Federal judges typically operate with complete independence, and their convergence on common strategies indicates shared perception of extraordinary threat. Former federal judges have played a crucial role in articulating the significance of these developments. Their perspective carries unique weight because they understand from direct experience the constraints and traditions that shape judicial behavior. When retired jurists from across the political spectrum describe current conditions as unprecedented in their experience, they are providing expert testimony about the breakdown of norms that have governed judicial-executive relations throughout their careers. These veteran jurists have emphasized several concerning patterns that distinguish the current situation from ordinary political friction. The specificity of attacks on individual judges, they note, represents a calculated effort to intimidate the judiciary by demonstrating that adverse rulings carry personal consequences. The coordination between executive rhetoric and grassroots harassment campaigns suggests institutional support for delegitimization strategies. And the willingness to contemplate impeachment as a response to routine judicial oversight reveals a fundamental rejection of the constitutional balance that has governed American government for generations. The language employed by sitting judges in their official opinions has become increasingly direct in documenting these concerns. Federal judicial writing traditionally adheres to conventions of restraint and formality, recognizing that opinions establish binding precedent and shape the development of American law. When judges abandon these conventions to employ phrases like contempt for the courts or unprecedented disregard for constitutional limits, they are signaling that ordinary legal vocabulary is inadequate to describe the conduct they are witnessing. This linguistic shift is not merely stylistic. It represents a deliberate choice to create a permanent record of constitutional resistance that future jurists, scholars, and citizens can consult. Federal judges are aware that their opinions become part of the historical archive of American law. By documenting executive conduct in these terms, they are ensuring that the record reflects the gravity of the constitutional moment, regardless of how immediate political contests are resolved. The implications of this judicial resistance extend beyond the immediate confrontation between the Trump administration and the federal courts. The judiciary's response is establishing precedents and practices that will shape how future administrations interact with judicial authority. If the current strategy of sustained defiance succeeds in eroding judicial independence, future presidents of any party will inherit expanded executive power unconstrained by meaningful legal oversight. Conversely, if the judiciary successfully defends its authority through contempt proceedings and documented resistance, the constitutional structure will emerge with its fundamental checks and balances intact, though perhaps permanently altered by the stress of this confrontation. The role of Chief Justice Roberts has been particularly significant in this context. His public intervention against impeachment threats represented more than defense of individual judges. It constituted a declaration that the judiciary would not permit its constitutional role to be politicized through intimidation. The Chief Justice's statement established that the judicial branch recognizes the threat posed by executive pressure and is prepared to respond through institutional means. This leadership has been essential in maintaining judicial unity across ideological lines. The federal judiciary includes appointees from administrations of both parties with widely varying jurisprudential philosophies. That these diverse jurists have converged on common strategies of resistance suggests that the threat to judicial independence transcends ordinary political disagreement. Conservative originalists and progressive living constitutionalists have found common cause in defense of the judiciary's institutional role, recognizing that without independence from executive pressure, no judicial philosophy can be meaningfully implemented. The contempt proceedings initiated by various federal courts represent the most concrete manifestation of this institutional defense. These actions transform judicial concern into enforceable legal obligations, creating mechanisms through which executive defiance can be punished and deterred. The willingness to employ these mechanisms against presidential administration officials demonstrates that the judiciary retains meaningful power even in confrontation with the politically most powerful branch. Looking forward, several indicators will reveal whether this judicial resistance successfully preserves constitutional boundaries or whether executive pressure ultimately overwhelms institutional constraints. The outcomes of pending contempt proceedings will be particularly significant. If the administration complies with judicial orders to avoid escalating penalties, the judiciary's enforcement power will be vindicated. If defiance continues despite contempt findings, the constitutional system will face a crisis of enforcement without clear precedent in modern American history. The evolution of judicial language in subsequent opinions will also provide important signals. If federal judges continue to employ urgent characterizations of executive conduct, or if their language becomes even more direct, it will indicate that they perceive the situation as deteriorating rather than stabilizing. Conversely, a return to more traditional judicial rhetoric might suggest either that executive conduct has moderated or that the judiciary has accepted constraints on its ability to influence administration behavior. Public statements from Chief Justice Roberts and other senior jurists will remain crucial indicators of institutional health. The Chief Justice has demonstrated willingness to intervene when he perceives genuine threats to judicial independence. Future statements or their absence will signal whether the judiciary continues to view the situation as requiring extraordinary institutional defense. Congressional response to these developments will also shape the constitutional landscape. The legislature possesses oversight mechanisms that could reinforce judicial independence or conversely could support executive challenges to judicial authority. The activation of these mechanisms in response to judicial signals would indicate that the constitutional system is functioning as designed, with multiple branches collaborating to preserve institutional boundaries. The fundamental question underlying these developments concerns the resilience of American constitutional democracy under sustained executive pressure. The federal judiciary was designed as the most insulated branch, protected from political retaliation through lifetime appointments and salary guarantees precisely so that it could serve as a check on executive and legislative overreach. The current confrontation tests whether these constitutional protections remain effective against an executive willing to deploy political pressure, public delegitimization, and institutional defiance to overcome judicial constraints. The outcome of this test will determine not merely the fate of specific policies or the tenure of particular officials, but the fundamental character of American government. A judiciary successfully intimidated into compliance with executive preferences would cease to function as a meaningful check on power, transforming the constitutional structure into something closer to parliamentary supremacy with executive dominance. Conversely, a judiciary that successfully defends its independence through contempt proceedings, documented resistance, and institutional solidarity will preserve the separation of powers that has distinguished American democracy. What emerges from this analysis is a constitutional moment of extraordinary significance. The federal judiciary has recognized that its independence faces a threat that requires active, coordinated defense. Through contempt proceedings, carefully crafted opinions, and institutional leadership, the courts are asserting their constitutional role with a clarity and force that has few historical precedents. Whether this defense succeeds will depend on factors that remain uncertain. The administration's response to enforcement actions, public support for judicial independence, and the willingness of other institutions to reinforce constitutional boundaries. The stakes could not be higher. The confrontation between the Trump administration and the federal judiciary represents a fundamental dispute over the nature of executive power in American democracy. The resolution of this dispute will shape the possibilities for constitutional government in the United States for generations to come, establishing precedents that will bind future administrations regardless of party or ideology. The judiciary's resistance has been remarkable in its unity and determination. Its ultimate success remains the critical, unanswered question of this constitutional moment.